Hey y'all, Daniel Gaines here. I'm gonna try and keep this fairly quick. Uh, but yeah, here, let me go ahead and do this. Let's uh, let's go ahead and get into it, shall we? With the first document here, the part that I want you to notice. Social worker asked Daniel about his home in Missouri, and he said it was not relevant to the case. Social worker told him that they had to assess safety in all homes. For one, the case has nothing to do with me. There's nothing against me, nothing about me, my history, or anything else that allows you to invade into my privacy like that. But we'll say that you can do so. And then you go on to say 3 kids who live there but refuse to provide their names. See, that makes it seem like you got salty because I wouldn't give you their names or that I did something wrong. The 3 minors that live here, Carolyn Murley, live here, but they're unrelated to the case. They're minors, so their information is protected. They're well outside of your jurisdiction, and you're trying to imply that I did something wrong by refusing to give it to you. And then whenever I told her I had no CPS history, no criminal history or anything else, she asked me to provide documentation in order for social worker to check things out. For one, I'm not supposed to have to prove my innocence. They're supposed to prove my guilt. It's called due process. And yes, CPS is supposed to uphold due process rights. But let's continue. Right here, Pilar Lopez, as you see, she says biological father has been making threats to slander CPS social worker's name, contact the medium, believes daughter was in the FTDM at 10:30 this morning, and is stating he does not have to follow Washington state laws. For one, I have audio recording, so you can claim whatever you wish. I need to see proof of me threatening to slander, because all I did was said I was going to put the audio recordings on YouTube, which I did, and that's not slander whenever it's actually factual. It's called reporting at that point, which is, again, what I did. But you go on to say, let's see, you reset up a new one, blah, 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 but it's still sort of fact that making threats to slander, all because I wouldn't kiss y'all's ass. Which I find kind of comical, because I'm not required to kiss your ass by law. And on this, I want you to notice this here. Social worker told her they would do their best. This is Juliet brought some items for our daughter. Social worker went through items and determined the clothes were dirty and smelly and would need to be washed. So she takes clothes to the department to CPS, and the stuff that she takes is dirty and smelly. But yet they're trying to rush to put my daughter back in the home of her mother, and they're still telling me I can't even be considered as an option. Kind of ironic, isn't it? But let's go on. That I just wanted to show you. That'll be addressed in court. But there's more I actually want you to see. Let's see. Where's it at? Right here. She said my daughter was talking about the golden rule, and it sent me into a tailspin about respect. See, the problem is these malicious claims. What they're doing is libel because they're falsifying documents that are with the court and everything else. Because I can prove that to be a lie. I can prove that she knows I lied. Or that she knows I lied. I can prove that she knowingly lied. I can prove this stuff beyond any doubt, without any room for anybody to argue the evidence that I can present. But yet, they put this shit in these documents, and it is filed with the courts. These documents were served to me, given to me through discovery, because they've been filed with the courts. But let's continue. Now, keep in mind, there is over 2,200 pages with this single document alone, and I'm only going to show y'all 11. But let's go on. Right here. It said she emailed me the dependency petition was provided. A long string of emails followed, uploaded, attempted to explain the reasons for the dependency. However, social worker was not successful in her attempts. The problem is I don't have those emails, and they're not in this document, which means they weren't filed with the courts. The thing is, if they would have filed those documents with the courts, those documents will show that it's not necessarily that I was not understanding the dependency, because I told her I understood that. What my question was is why wasn't I even considered as an option? That's what she was failing to understand. That's what she couldn't understand. That's where my whole entire issue was. And again, I can prove beyond any doubt that this is factual statements I'm making here. And I'm going to do so starting Tuesday of next week. Y'all will see, I promise. I promise y'all will see every bit of it. Promise you. But let's continue. Hold on, I'm trying to see what I'm looking for. Sorry, y'all. I don't know, I guess on that one. Maybe, hold on. Was I on the right page? Oh, I don't know. I don't know. This one, I don't know what the hell I was supposed to be looking for. Maybe I wrote the wrong page number. Either way, it's still going to be 10 pages. Here we go. On this, it says social worker called Faith to follow up with her after social worker received a report about a visit that had gone awry. The day prior, Faith stated during the phone call with Daniel that he started yelling at the visit supervisor. She stated she didn't want to hear it, so she just hung up. On top of that, she stated she was hungry and wanted to get off the phone anyway. Social worker thanked her for clarifying. The problem with that is that it's extremely out of context. I don't know if Jarrell intentionally left out context, or if Faith inadvertently didn't add context, or if she intentionally didn't add context. I have no idea. Alls I know is it was out of context. I can prove it. I can prove I never yelled at the lady. However, I did have a few words for her, because what the context is what's missing is me and my daughter were having a conversation. There was no stipulations in the court order saying that I couldn't talk to my daughter about any specific thing, meaning anything I wanted to talk to my daughter about, I was legally allowed. The lady who was listening to the calls, in violation of my constitutionally protected rights, might I add, which again, that's something I'll prove in court beyond any doubt. They won't be able to argue with the case that I'll be presenting to prove that. But illegally monitoring the calls anyway, supervising the calls anyway, she interrupted and said I wasn't allowed to talk about something. And when she did, I called her and said, right now you're violating a court order. And that's the way it went. I told a lady she was violating a court order. She says, no, I'm not. Yes, actually you are, because the court order doesn't specify that there's anything off limits. I don't care what the department said. I'm telling you what the court order said. If that's a problem, that's something you need to take up with them. Otherwise, don't violate the court order. And that's pretty much how it went. And again, it's stuff that I can prove. I don't care what they say. I can prove differently. Like I said, I can prove every one of my claims beyond any doubt, and it's completely irrefutable evidence that I can present and will be presenting when it's proper time for that, i.e. the lawsuit. I can prove all this. and everybody's going to be privy to that proof. Just have to wait till it gets to the proper time for that first. But I promise you, it's all some bullshit. Let's see. Right here, this is something I don't even know when it was actually filed or whatever. But it claims right here, Daniel denied substance abuse, DV, mental health, maltreatment as a child, and criminal history. This is contradicted by some of the provided documentation, dishonorable discharge, and Juliet's statement. The problem is the provided documents and Juliet's statement were all provided from Juliet, none of which are factual, none of which there's any actual proof of. It was a generic document she sent that basically was something that anybody could type up, and it wasn't official in any way, shape, form, or fashion. It didn't have any of the official markings or anything else, but yet they're reporting it as it's factual, whenever in fact it's actually hearsay. But they don't care about due process because they think they're fucking untouchable. What these morons at the department fail to understand is they only have qualified immunity, but we'll get to qualified immunity here in just a minute. I'll get there all in a second. Let's finish these documents up. Then we come to this one. Now, I want you to notice something here. Date of assessment. 4/2/2020, April of 2020. This right here, there is an active criminal investigation. There is a protective order between Miss Parker and Faith. There is a parenting plan denying Mr. Gaines any contact with Faith. See, the problem with this is they were presented in early March a court order from Mason County, Washington, that gave me access to my daughter. The exact opposite of what they put on this court document. And it's verifiable by the court order that I've already shown from March of this year. They had almost a month before they put this in there, and they intentionally and maliciously put false information in this document to try and interfere with my parental rights. And this is the department. This is DCYF. Not Juliet. This is the fucking state of Washington trying to maliciously interfere with my parental rights. Because it's factually incorrect, and they were well aware of this because I personally took the fucking document into their office after spending all the money to spend a week in Washington almost to get this shit dealt with. And they can say whatever the fuck they want about things because the same fucking clown-ass judge who signed the order in March of this year, check this out. The same fucking clown in a robe who signed the order in March of this year is the same robed clown who signed the fucking, the default order in 2015 from Mason County. Same fucking guy. And he straight told me once he started actually looking through the case file in his courtroom, he told me he remembered this case after he started looking through the case file and it refreshed his memory. And, I mean, that's straight what he said. He said he remembered it. And he still signed the order giving me access to my daughter. But yet the department maliciously falsifies the documents stating that there is a order denying me any contact. And they know it's bullshit and not true. Let's see. Hold on, there's something on this page. Let me read through it real quick. Oh yeah, I think it's right here, yeah. It says there is a parenting plan granting Mr. Gaines only supervised contact with Faith. Mr. Gaines motioned to change that plan but did not show for the last hearing. The department continues to receive law enforcement that the investigation is active and ongoing and may result in other adults being charged. The investigation is into Juliet's criminal investigation, nothing to do with me. But only supervised contact. No, actually, that's not what the order said. The order from Mason County gave me access to talk to my daughter. Didn't have amount of times. It gave me, I could talk to her on the phone as much as I wanted. It didn't give me access to see her illegally in violation of my rights, but there was no stipulations on the phone calls. They were aware of this when at the time of this document being filed. And besides the fact, there's still the problem, even if they go off the court order that Pierce County during the early hearings for dependency put in place, the problem that they run into is this says supervised contact. The problem is the Ninth Circuit District Court, which is over the state of Washington, actually has case law that states, absent due process, they're not allowed to monitor, record, supervise, or anything else, any contact or communications or telephonically, written, or anything of the like between you and your child. Now, I've yet to have a trial. The trial doesn't start until Tuesday, October 13th. So if I've yet to have a trial, what due process rights was I afforded in order for them to justify the supervised contact? See the problems they're running into? And as far as me not showing, what they neglected to leave out was the hearing I didn't show up for was to extend the restraining order. At the time that I got the court order from Mason County in March of 2020, it was a temporary restraining order and an order giving me access to my daughter. The only thing that was being heard the day I missed was to extend the protective order. I didn't need to extend the protective order. I'm back in my home state. I actually don't need a protective order anyway. So it was just something that had to be filed with the original document. So I filed it. I didn't need it. I wasn't in the state anymore. It was mainly to, keep her away from me while I was in the state for the most part anyway. But I didn't need to. I didn't need the protective order extended. And that's what I didn't show up to. They make it seem like it was about contact with my daughter that I didn't show up to. And no, that's incredibly far from being fucking accurate. And they're well aware of this. But again, they maliciously put this shit in here just to try and interfere with my parental rights. And they think I'm too stupid to know the difference. And in the last, not the last one, but almost the last one right here, Mr. Gaines resides out of state. He has not actively fathered Faith in a number of years, and the last parenting plan filed did not allow him contact with Faith. The problem is there was, actually that's right. He filed to amend the parenting plan, but did not show for the last hearing. And see, again, that's them implying that I ignored the parenting plan hearing, which is not the case. What was ignored was the protective order hearing, and again, I can prove this. I have the fucking documents, you stupid motherfuckers. The court in the dependency case has authorized supervised phone contact between Mrs. Gaines and Faith. Or between Mr. Gaines and Faith. Again, the problem is they authorized supervised contact, but what due process rights was I afforded for them to determine there was sufficient evidence to warrant the intrusion upon my constitutionally protected rights? It is a thing called due process, and independency, family law, and everything else, regardless of what these stupid fucking criminals want to tell you. It does actually have to be upheld. In fact, the United States Supreme Court has already stated and affirmed many times that when it comes to matters of custody and parental rights, your due process rights are to be more securely safeguarded by the courts. But anyway, Mr. Gaines has sent a number of emails to CPF staff, which has been threatening and concerning in nature. He has reported that he is recording phone calls with the CPS worker despite being told he does not have permission to do this. Now, before I go on to that last sentence there, let's break this down. Look up RCW, which is Washington laws, for threatening. You'll find that none of the emails I've sent ever have reached that threshold. They're accusing me of being threatening and intimidating and harassing because I was recording their phone calls. I guess they forgot about this little thing. Well, I'll get into that in a minute. It's actually the next one I'm going to show you anyway. Saying that despite being told that I don't have permission to record them, I was doing it anyway. Well, the problem is I don't fall under the jurisdiction of the state of Washington. The state of Washington does not and has never had jurisdiction over me, which means I'm not legally obligated to follow, Washington laws. Missouri laws are different than Washington laws when it comes to audio recordings. Washington is known as a two-party consent state. Missouri is a one-party consent state. In a two-party consent state, all parties involved in the audio recording must give their consent to be recorded. In a one-party consent state, as long as one person on the call, on the recording, knows it's being recorded and consents to it, it's completely legal. Missouri Revised Statute 542.402.2. You can look this up to confirm that I'm not wrong. I'm factually correct. Being a Missouri resident, I can stand in my home all day long, or even anywhere in this state, and record anything I fucking want, including calls from other states. They can kiss my ass. It's legal. Now, this is the part that's really going to be fun to question them on right here. The department has concerns about Mr. Gaines' mental health based on the phone calls and emails received. Or the phone calls and emails received. Meaning based on the fact that they're concerned that I have mental health issues because I'm recording them, violating my rights in the law, and because I keep telling them in emails, y'all stupid motherfuckers are going to get sued if you keep it up. But is what they're not admitting to, and is what they're intentionally and maliciously excluding from all these documents, is all the information that I can prove before I started getting pissed off. That's me asking, begging, pleading for them to follow the law and uphold my rights. That's me working with them, being completely complicit, civil, and everything else with them. It wasn't until after they started violating my rights and or basically telling me, actually it was after I was literally told that I wasn't even able to be an option for placement, that I started getting a little bit of an attitude because, well, as her father, why am I not even considered a possibility? Well, and it kept going from there. So yeah, then I did start getting pissed off and I was recording phone calls. But the thing is, you have concerns. What legal grounds or what legal precedent or case law or anything else gives you the right to put this in a court document without any kind of evaluation being done, without any kind of even experts speaking to me or anything else? What gives you the right to put something like this simply because I'm upset and pissed off about the violations of my rights? You don't get to cover your ass because of your criminal conduct claiming I have a mental health issue. The problem with your claiming I have a mental health issue is I'm about to completely fucking destroy it in court. The problem with your mental health issue claim is I can prove that it doesn't exist. I'll leave that for the lawsuit. Yeah, I'm not going to get into too much detail about that yet, but let's just say I've already covered my bases on that. Let's just say that a mental health eval is only going to come back showing that I'm pissed off about the fact that my rights have been violated for almost 2 fucking decades. It'll show that I'm pissed off about missing my daughter's entire fucking childhood because of you criminal cock-sucking bastards. That's only natural. That's human nature to be mad if somebody does something to your children. It's only human nature to be pissed off when someone harms your child. And y'all claiming that my child hasn't been harmed? Bullshit. Look at all the fucking studies that prove children who are alienated away from one parent or only raised by one parent have all kinds of different orders. These documents will prove and show my daughters had suicidal thoughts. My daughters attempted to take her own life on more than one occasion. These documents verify this. Tell me my daughter doesn't have issues with mental health? Well, part of that probably stems from the fact that she was alienated from her father her entire life because, as I said, psychologists, experts will tell you there is effects when you remove a parent from a child's life. children actually benefit the best when they get to have both parents in their life. She robbed me and her daughter of, it's actually child abuse what she did, and everything else. But again, I'm not getting into all these laws and codes specifically because it's all going to be brought up in trial. It'll all be cited then. They're fucked in trial, and I mean they really have no out for anything. I'm even going to force them to admit. Well, hold on, I'll get there right now. This next document's a bit jacked up. It's sideways, so we got to kind of do this. This is the order that Farmer put in place, right? Hold on here. Okay. It says that the court ruled that Mr. Gaines' behavior is bordering on harassment. His behavior is intimidating to state workers. The problem is, if you look up the RCW for harassment and intimidation, what they're accusing me of doing does not even come close. At which point, Mr. Gaines interrupted the judge. The court ruled that if the phone call is a call, The court ruled that if the phone call is a call the state initiates, Mr. Gaines cannot record the conversation. Mr. Gaines interrupted the judge multiple times, shouting that his rights are being violated. If Mr. Gaines calls the state, the court cannot stop him from recording. The court is barring any harassing type action. She specifically said no more posting on YouTube of any recordings of any state worker, GAL, or anything involving the minor. Mr. Gaines kept objecting, saying it was a violation of his rights and he does not have to comply with court orders he feels is unjust. Actually, I said I don't have to comply with any court order that is illegal and invalid. Not that something I feel is unjust. And I actually have U.S. Supreme Court case law I will be citing during the trial to support the fact that I am not obligated by any law to follow any invalid court order. And see, this was overturned anyway because the bitch violated my rights on this. So I got it overturned because she got it wrong anyway. However, there's all kinds of things wrong here. One is, this is going to be used alone to prove that this commissioner, Terry Farmer, is guilty of violating my rights. This document alone is going to prove that they're all complicit in the violation of my rights. Because, see, they're all state employees. Every single one of them. The department is. It doesn't matter if it's a 1-party, 2-party, 20-party consent state. The United States Supreme Court has ruled state officials, state employees can be recorded at any given time. You do not need their consent. They are state employees. It is your constitutionally protected First Amendment right to do so. So everything in here, literally everything she did here, is a violation of my constitutionally protected rights. They say I'm sitting here telling the judge or the commissioner she's violating my rights. That's exactly what it was. And whenever I cite this piece of case law to these people in court, whenever they're on the witness stand taking questions from me, that's one thing they're going to be asked. Based off the case law I just presented to you, is it fair and true to state Commissioner Farmer, along with everybody else who had anything to do with this, is guilty of the violation of my constitutionally protected rights? The only fucking answer left to give at this point for all of these people is yes, we are all guilty of violating your constitutionally protected rights. Because there's nothing they can say. Because they also neglect to mention what the federal law states as far as audio recordings go. Federal law has far more legal authority than state law, but yet they didn't mention anything about what the federal law stated in their bullshit cease and desist motion. They didn't mention anything about Missouri law, and the best part of it is whenever I bring up jurisdiction at the very beginning of the trial and how they lack personal jurisdiction over me, they're going to claim, oh, Mr. Gaines, you being involved in the court proceedings without being under special appearance as giving jurisdiction to the state. Actually, you're wrong, because I can show emails, or I can play audio recordings and everything else that will show that from the very beginning, since February, I have maintained I am a Missouri resident. Therefore, I am not subject to the laws of the state of Washington. I can also show where I have a cease and desist that was overturned after Commissioner Farmer violated my rights. along with everybody else involved. It was overturned because of Missouri law. I didn't even use federal, I used Missouri law, and that was intentional. See, is what you guys fail to realize is I've set you up to take this fall because you fucks were warned not to play with me when it comes to my rights. Here, I'll throw you this bone because there's nothing you can do about it, literally. The reason Missouri law was cited is this. Missouri law was the reason the cease and desist is overturned. That right there is the courts admitting the courts do not have jurisdiction over me. The state of Missouri has jurisdiction over me. Missouri law was used because Missouri is where my personal jurisdiction resides. You idiots are too stupid to understand you've been fully fucking played. And it was your own doing. All I wanted you to do was follow the law and uphold my rights. None of this would have happened had you have done that. Instead, you stupid motherfuckers thought you were above the law, thought you could do whatever the fuck you wanted and everything else. Because you think you're untouchable, because you think you have fucking absolute immunity. What you really have is this right here. Sorry, trying to make this quick. Qualified immunity. Basically, qualified immunity applies to government officials in civil litigation and does not protect the government itself, which is fine, but less strict than absolute immunity. It is intended to protect officials who make reasonable but mistaken judgments. But is what the main thing is unless the plaintiff shows that the official violated clearly established statutory or constitutional rights of which a reasonable person would have known. The problem for them is they were all sent the fucking case law months ago, and I can prove it because not only do I have the video, I also have the green cards from all of them signing for it. The department, the attorney general for the state, judge, and all of them, they were all sent the case law. Their qualified immunity just went out the fucking window at that point. They've got no excuses. Have a good day, y'all. I love y'all. Y'all wait for my trial. You're going to love this. It's going to be epic, I promise.